In my 40 years on the bench, I've encountered every flavor of excuse a human being can manufacture. The dog ate the registration, the ticket blew off the windshield, the sign was hidden behind a tree. I've heard them all, and I say this without judgment, because sometimes people are genuinely confused, genuinely unlucky, genuinely caught in circumstances beyond their control. I extend every reasonable benefit of the doubt. That's my obligation as a judge and my nature as a person. But every so often someone walks into my courtroom who has decided, somewhere deep in their thinking, that nothing that happens to them is ever their fault. The other driver, the parking officer, the city, the weather, everyone and everything is responsible, except the one person standing right in front of me. This case was one of those, and what I had to do that day wasn't just rule on the violations. I had to hold up a mirror to a man who hadn't looked honestly at himself in a very long time. When this case landed on my desk, the file was thicker than most. That alone told me something. The defendant was a 38-year-old man named Raymond Castillo. The charges before my court were not minor. 2 counts of reckless driving, 1 count of failure to yield at an intersection resulting in a collision, a citation for driving with a suspended license, and an outstanding fine from a previous violation he had never paid. The total outstanding amount, including penalties and late fees, had climbed to over $900. What concerned me first as I read through the file was the pattern. This was not Raymond's first appearance in traffic court. He had been cited 4 times in the previous 3 years. A rear-end collision he'd been found at fault for, 2 speeding violations, and a failure to stop that had been adjudicated and fined. He had paid one of those fines. 1. The more recent matter, the collision at the intersection, was the most serious and the one that had finally triggered the suspended license status. According to the police report, Raymond had failed to yield while making a left turn, striking a vehicle driven by a 71-year-old woman named Eleanor Marsh. Mrs. Marsh had suffered a bruised shoulder and a significant emotional shock. Her vehicle had sustained damage to the driver's side door. She had been taken to the emergency room as a precaution. I read that part twice, a 71-year-old woman shaken and hurt because someone had failed to pay attention at an intersection. I set the file down. I thought about what I was likely to hear when Raymond Castillo walked through my door, and I prepared myself. Let me walk you through what happened at that intersection, because the facts of this case matter, and they tell a story that Raymond himself had significantly rearranged in his own mind by the time he arrived in my courtroom. It was a Tuesday afternoon, just after 3 p.m. Raymond was driving his vehicle westbound on a main arterial road through a busy section of the city. He approached an intersection with a dedicated left turn signal, the kind with its own green arrow, specifically designed so that turning drivers and oncoming traffic are not moving simultaneously. According to the police report and 2 independent witnesses who gave statements, the left turn arrow had already cycled back to red by the time Raymond's vehicle entered the intersection to complete the turn. He had, in the words of one witness, just kept going like the light didn't apply to him. Eleanor Marsh was traveling eastbound through the same intersection on a green light. She had every legal right to be moving. She had no reason to anticipate a vehicle turning across her path against a signal. When I reviewed the intersection camera footage during my case preparation, I saw the moment clearly. Raymond's vehicle entered the turn after the arrow had expired. Mrs. Marsh's vehicle, moving lawfully, had no time to stop. The impact was on the driver's side. I want to tell you, honestly, what went through me when I watched that footage. Eleanor Marsh was 71 years old. She was driving carefully within the speed limit through a green light on a Tuesday afternoon, and in an instant, through no action of her own, her door was caved in, and she was on her way to an emergency room. When I thought about her in that moment, her age, her shock, the bruise on her shoulder, the trauma of being struck in a vehicle, I felt something heavy settle in my chest. Because she did everything right, and she still got hurt. I had to take a breath, compose myself. And then I turned to Raymond's version of events. In the statement he provided to the responding officers at the scene, Raymond had said the following: that the light might have been yellow, that Mrs. Marsh had been speeding and came out of nowhere, and that the intersection was confusing because of recent road construction nearby. 3 separate deflections, 3 separate attempts to distribute the responsibility somewhere, anywhere, other than onto himself. I've been doing this long enough to know when a story has been constructed backward from a desired conclusion. And that's exactly what I was reading. As I continued reviewing the full body of evidence, the weight of Raymond's record and the consistency of his pattern became impossible to ignore. The intersection camera footage was unambiguous. I had our court's copy reviewed frame by frame. The left turn arrow had been read for a full 1.8 seconds before Raymond's vehicle crossed into the intersection. Not yellow, not a gray area, red. The claim that Mrs. Marsh had been speeding was addressed directly in the officer's report. The posted speed limit at that intersection was 35 miles per hour. The officer, using standard impact analysis and the camera footage, estimated Mrs. Marsh's speed at the time of impact at approximately 30 to 32 miles per hour. She was, if anything, traveling slightly under the limit. The claim that the intersection was confusing due to construction, I had my clerk pull the city's roadwork records. The construction Raymond referenced had been completed 14 months prior. There were no active construction warnings, no altered signal patterns, nothing that would reasonably create confusion at that intersection on the day in question. One by one, each piece of deflection collapsed under examination. And then there was the license. Raymond's license had been suspended following the non-payment of a prior fine and a mandatory points review triggered by his driving record. He had received written notice of the suspension by certified mail. He had signed for that notice. He knew his license was suspended, and he had continued driving for an estimated 4 months based on his own incidental statements to the officer at the scene after receiving that notice. The witnesses who had seen the intersection incident were consistent. Both described a vehicle that did not slow or hesitate before making the turn. Neither described anything that supported Raymond's account of the circumstances. What struck me most, reading all of this, was not the violations themselves. It was the picture they painted together. This was a man who had been accumulating consequences for 3 years and had spent that entire time explaining why none of them were his fault. The rear-end collision, the other driver stopped too suddenly, the speeding tickets, the speed limit signs weren't clearly visible, the unpaid fines, the payment system was difficult to navigate, and now this. There is a certain kind of exhaustion that comes, after 40 years on this bench, from watching someone carry a story that is slowly destroying their life, and being utterly committed to that story anyway. That's what I felt reading this file. Not anger, exhaustion, and underneath it, genuine concern for what lay ahead for this man if nothing changed. By the time Raymond's court date arrived, I was told that some elements of the case, particularly the intersection camera footage and the circumstances surrounding Mrs. Marsh, had been discussed on local news. My staff mentioned that there had been some public commentary online and that people were following the outcome with interest. I'll tell you what I felt about that. Nothing in terms of how I approached the case, and I mean that sincerely. I've had cases that drew significant public attention over the years, and my approach has never wavered based on who is watching. The moment I allow public sentiment to pull my rulings in either direction, toward severity because people are angry, or toward leniency because people are sympathetic, I've failed at the most fundamental part of this job. I'm not a performer, I'm a judge, and the camera, whether it's a news camera or a phone, doesn't change what the law requires or what the person in front of me needs to hear. What I did note, and what I thought about carefully, was that Mrs. Marsh deserved to have her experience acknowledged in a public setting. She had done nothing wrong, she had been hurt through no fault of her own, and she deserved to hear in clear terms that the court saw that fully and completely. As for Raymond, whatever was said online about him, he deserved the same fair hearing I give every person who stands before me. Public opinion is not evidence. Anger is not a verdict. My job is to look at the facts, look at the person, and respond to both honestly. That's what I did. When Raymond Castillo walked into my courtroom, I observed him carefully, as I do with every defendant, before a single word was spoken between us. He was dressed neatly, which I appreciated. He carried himself with a kind of practiced confidence, not arrogance exactly, but the bearing of someone who had been in difficult conversations before and had developed a strategy for them. He looked around the room, spotted where his case number was posted, and made his way to the appropriate position. Mrs. Marsh was seated in the gallery, her arm in a soft brace. She was a small, composed woman with white hair and the patient expression of someone who had been through something unsettling and had chosen, quietly, not to be defined by it. I found myself grateful for her presence and her dignity. When Raymond's case was called and he stepped forward, I greeted him courteously, as I greet everyone. I said, "Mr. Castillo, good morning. I've reviewed your file thoroughly. Before we discuss the specific charges, I want to give you the opportunity to speak. Tell me, in your own words, what happened at that intersection." He was ready for that question. I could tell immediately. The answer came with a certain practiced smoothness. He told me the light was ambiguous, that road conditions had been difficult, that the other driver had appeared suddenly. He was measured, articulate, and completely consistent with the written statement he'd given the officer. I listened to every word. I let him finish entirely before I said anything. Then I said, "Mr. Castillo, I appreciate you sharing that. I want to walk through the evidence with you, and I'd like you to listen carefully." I presented the intersection camera footage first. I didn't editorialize. I simply described what the footage showed, frame by frame, the signal, the timing, the entry of his vehicle, the path of Mrs. Marsh's vehicle. When I finished, I said, "Mr. Castillo, based on what I've just described, the left turn arrow had been red for 1.8 seconds before your vehicle entered the intersection. Does that change anything in your recollection?" He paused. Then he said, "The camera angle might not capture everything accurately." I took a slow breath. I said, "The camera is a fixed intersection-mounted unit. It captures a direct overhead view of the signal and the traffic pattern simultaneously. There is no angle distortion relevant to what it recorded." He said, "I just feel like the situation was more complicated than it looks on camera." I set down the papers I was holding, quietly, deliberately. I said, "Mr. Castillo, let me ask you something directly. In your statement to the officer, you said Mrs. Marsh was speeding. The analysis of the footage places her speed at 30 to 32 miles per hour in a 35 mile per hour zone. Do you maintain that she was speeding?" A pause. She felt like she came fast. I said, "Feeling and fact are two different things, and in this courtroom we work with facts. The facts say she was traveling under the speed limit." I moved to the construction claim. I told him that the roadwork he referenced had been completed 14 months prior, and that there were no active construction conditions at that intersection on the day in question. He started to respond. I said gently, "Mr. Castillo, let me finish, please." I said, "I've now addressed 3 separate explanations you've offered for what happened at that intersection: the signal timing, Mrs. Marsh's speed, and the construction. Each one, when measured against the documented evidence, does not hold up. I want you to understand something important. I'm not telling you this to embarrass you. I'm telling you this because I need you to understand that I've done my homework, and because what comes next requires honesty from both of us." He was quiet. The practiced confidence had loosened slightly. I turned briefly to Mrs. Marsh. I said, "Mrs. Marsh, I want to acknowledge you directly. You were driving lawfully, carefully, on a green light. What happened to you was not your fault in any respect. This court sees that clearly, and I want you to hear me say it out loud." She nodded. Her eyes were steady and grateful. I turned back to Raymond. I said, "Mr. Castillo, I want to ask you about your license. You received certified notice of suspension 4 months before this incident. You signed for that notice. Are you telling me you were unaware that your license was suspended when you got behind the wheel that afternoon?" A long pause. He said, "I thought maybe it had been resolved." I said, "Did you take any steps to confirm that it had been resolved? Did you contact the DMV, file any paperwork, receive any written confirmation?" The pause that followed answered the question before he did. He said quietly, "No." I said, "So you assumed, you hoped, and you drove anyway." He didn't answer. I looked at him for a long moment. He was no longer the man who had walked in with a practiced story. Something was shifting. I said, "Mr. Castillo, I've been a judge for 40 years. And in those 40 years, I have learned to recognize something that I'm seeing clearly right now. You are an intelligent man, you are articulate, you've prepared for this. But somewhere along the way, you developed a habit of explaining your circumstances outward, of finding the reason that what happened was someone else's responsibility, the other driver, the signal, the construction, the payment system. And I want you to hear me when I say this. That habit is not protecting you, it's costing you. It has been costing you for years. He looked at me. Something in his eyes had changed. I said, I'm not saying this to lecture you. I'm saying it because it's true, and because the evidence in this file shows me a pattern, and because you are 38 years old with decades of driving ahead of you, and I would rather tell you this now than see you back in front of me, or someone else, under worse circumstances. I've been on this bench long enough to know that a sentencing speech isn't really about the sentence. It's about the moment, about whether when a person walks out of your courtroom, they carry something with them that might actually change the trajectory they're on. I looked at Raymond Castillo and I said, Mr. Castillo, I want you to hear what I'm about to say, and I want you to take it seriously. I paused. Every single charge before me today is supported by evidence that is clear, documented, and unambiguous. You ran a red light. You struck another vehicle. You injured a 71-year-old woman who was driving lawfully. You did all of this on a suspended license. These are facts, not interpretations. Facts. I paused again. But here is what I also see. I see a man who is not malicious, who is not reckless in the way that word implies indifference to human life. I believe you did not intend to hurt Mrs. Marsh. I believe that. What I also believe is that a pattern of inattention, of deferred responsibility, of assuming things have been handled when you haven't verified that they've been handled. That pattern has consequences in the real world. And today those consequences included a 71-year-old woman in an emergency room. I let that sit. Here is what I am ordering. On the collision and failure to yield, a fine of $350 with a mandatory defensive driving course to be completed within 60 days and proof of completion filed with this court. This is not optional. You need to sit in a classroom and relearn formally what careful driving looks like. On the suspended license charge, an additional fine of $250 and a mandatory 6-month extension of your suspension period. During that period, you will not operate a motor vehicle. If you are cited for driving during that period, you will face significantly more serious consequences than anything I am ordering today. On the outstanding prior fine, you will pay the remaining balance of $320 in monthly installments, beginning 30 days from today, with a structured payment plan filed through the court clerk's office before you leave this building. Additionally, I am asking, not ordering, but genuinely asking, that you write a letter of apology to Mrs. Marsh. You don't have to send it if you choose not to, but I want you to write it. I want you to sit down alone and put into words what happened to her because of decisions you made. I think that exercise will teach you more than any fine I could impose. I leaned forward. Mr. Castillo, you had choices at every point in this story. You had a choice at that intersection. You had a choice when you received that suspension notice. You had a choice each of the 4 times prior when the court gave you the opportunity to address your record, and you did not. You made poor choices, consistently, over a period of years. But here's what I also believe with every bit of experience I have. You can make different ones going forward. That's your decision to make. I hope you make it. After I delivered the sentence, the courtroom was very quiet for a moment. That kind of quiet that settles when something has been said that people recognize as true and necessary. I glanced at Mrs. Marsh. She had her hands folded in her lap, and her eyes were calm. After the session concluded, she approached the bench briefly. She thanked me, and I told her what I meant entirely, that she had shown more grace throughout this process than anyone could have been required to show, and that she deserved every bit of the acknowledgement she'd received. Raymond stood near the clerk's office for a while after, working through the payment plan paperwork. I didn't speak with him again directly, but my court officer told me quietly that Raymond had asked for Mrs. Marsh's mailing address for the letter. I'll tell you what that meant to me. It meant something had gotten through, not the fine, not the extension of his suspension, the conversation, the mirror. I spoke with my staff at the end of that day, and I said what I've said many times over 4 decades. The most important thing I can do in that courtroom isn't impose a penalty. It's create a moment of genuine clarity for the person standing in front of me, a moment where, if they're open to it, something shifts. The cases that go the way Raymond's went, where you can see the shift happening in real time, in a man's eyes. in the way his shoulders change. Those are the cases that remind me why I still do this job. Not the simple ones, not the clean ones. The complicated ones, where the truth has to be coaxed out patiently, carefully, without anger, without theater. Just two people in a courtroom, one of whom has the responsibility to see clearly and speak honestly. Let me tell you what I hope people take from this case, because I think it reaches far beyond a traffic court in Providence. We live in a culture that has become remarkably skilled at deflection. Social media has given everyone a platform to tell their own version of every story, always as the reasonable party, always facing unreasonable circumstances, always surrounded by people who didn't do their part. And I understand the impulse. Accountability is uncomfortable. Owning your mistakes requires a kind of courage that doesn't come naturally to anyone. But here is what I have watched from this bench for 40 years. The people who learn to own their mistakes early, who can stand in a difficult moment and say, clearly and without qualification, I made a poor choice and I'm going to do better. Those people move through life with a freedom that the deflectors never find. They build trust. They recover from setbacks. They don't accumulate the kind of file that Raymond Castillo walked in with. Mrs. Marsh was 71 years old and had done nothing wrong. She deserved better than what happened to her. She deserved more than a bruised shoulder and a damaged door and a trip to the emergency room on a Tuesday afternoon. She got hurt because someone made a series of choices and spent years explaining them away. Don't be that person. Look at yourself honestly. Own what's yours. Because your choices, behind the wheel in your relationships, in your life, they have consequences for real people. And those people deserve your attention, your care, and your accountability.